That's the last I'll say about that. All right, so criminal law, just big, broad, 50,000 foot level again. I want you to think about kind of how we've set everything up in this class. We talked about civil law for the last couple weeks. Tort law was all civil law. Intellectual property is all civil law. Most everything we talk about will be civil law. But this week, we're going to focus on criminal law. So I want to make sure that we highlight the differences between criminal law and civil law. So this is a quick review. Remember that the burden of proof in criminal law is different than the burden of proof in civil law. Civil law was preponderance of the evidence. More likely than not, 51% to 49%. Okay? Criminal law, again, the burden of proof is beyond a reasonable doubt. Not beyond a shadow of doubt, not beyond any doubt whatsoever, not 100%, beyond a reasonable doubt. And that makes sense to us because in civil law, with a lower burden of proof, what was at stake there was mostly money damages. What's at stake in criminal law is potential loss of freedom, being incarcerated, in extreme cases, death penalty, having a criminal record. Those are things that we have decided as a society are going to require a much higher level of proof in order to convict somebody or have somebody be liable for crimes. Okay? So that's another big difference. Remember that in civil law, the plaintiff could be the victim, could be the person who's been harmed, who has suffered loss, who needs to be compensated. In criminal law, the plaintiff is always going to be the government. The victim doesn't get to sue for a crime. So if it's a federal crime, the plaintiff is the USA. If it's a state crime, the plaintiff is the state of whatever it is. The defendant in a criminal case is the one who is alleged to have committed the crime. We classify crimes in a couple different ways. You've probably heard of felonies and misdemeanors. Misdemeanors are less serious crimes. Felonies are the more serious crimes. The line between them is usually something like a year or more in prison is associated with felonies. A year or less in prison is associated with misdemeanors. We have federal crimes that are violations of U.S. law. We have state crimes that are violation of each individual state law. Something that is unique to criminal law is that criminal law is entirely statutory. Okay? In order for an act to be criminal, there has to have been a law passed specifically outlawing or criminalizing that activity. The government can't make up a crime that's not on the books to charge me with. Can't be prosecuted for that. They've got to go look through, it's a big book, the book of all the criminal statutes and decide based on what I did, what crime that fits the definition of. Just like in tort law, one set of acts could result in multiple crimes. Remember that one set of acts could result in criminal liability and civil tort liability. Me punching Ryan in the face, it's a tort and a crime. Crimes could also be defined or differentiated by degree. You've heard of like first degree murder, second degree murder, grand theft or grand larceny, petty larceny. That's usually, it's going to depend on how the statute defines the crime, but it's usually the degrees, the more serious the more serious the consequences or the more dangerous the force that was used. That's usually what differentiates them. In the case of all crimes, because they're statutory, they're going to be defined by law. And it's going to say a person who commits the offense of murder has done these things. It's got to spell out what the prohibited acts are. And each criminal statute is going to tell you what state of mind the actor had to have. So, for example, if you read a murder statute, it's going to say a person has committed the offense of murder if they take the life of another without justification in a premeditated manner, meaning it was planned. Okay, so we read that and we could not infer, it's explicit in the statute. We would know that the prohibited act is the taking of the life of another without justification. And the state of mind that's required for that crime is premeditated intent. Let's say that I got into my car Saturday night after drinking heavily at a bar downtown, and I drove home and killed somebody with my vehicle. The state wants to look at my conduct, and they're going through all the different crimes they could charge me with, and they look at murder. They may not charge me with murder, because if you look at that definition, it says I had to have premeditated intent to have committed that crime. So maybe not murder. I didn't plan that out. I didn't intend to kill somebody with my car. But they might find another criminal statute like manslaughter. And if you read the manslaughter definition, it would be something like taking of the life of another without justification, by engaging in reckless conduct. Recklessness, the intentional taking of a known appreciated risk. I didn't intend to kill anybody, but I certainly knew or should have known that getting behind the wheel severely intoxicated could result in somebody losing their life. That's reckless conduct. So every statute is going to define the prohibited conduct and the state of mind that's required. It could be intent, could be recklessness, could be negligence. Remember, we talked about negligence in the civil sense in tort law. Negligence required the existence of a duty to behave carefully. The breach of that duty, the breach caused the injury. Y'all remember that from tort law? There can also be criminal negligence as well. I had a duty to drive carefully, but I breached that duty by being drunk or blindfolding myself. I can think of a lot of different examples. Maybe remember our dude that was Johnny was firing the gun into the woods indiscriminately. That could be criminal negligence. It could be civil negligence also, but it could be criminal negligence as well. Some crimes, like when we talked about in tort law, that require no intent at all, strict liability. Remember that, like when we're abnormally dangerous activities, operating dynamite, owning tigers, things like that. Some statutes, some criminal statutes will say no intent required at all. The only thing that matters is, did you do it? An example, and they're rare. We don't as a society have a lot of crimes that we're going to do things as serious as take people's liberty or have them have a criminal record when they didn't even intend to do what they did. Example of strict liability crime is like statutory rape. It will be defined as a person over the 18 having sex with a person under the age of 18, regardless of whether they knew it or not. Those are status offenses. I mean, the person was a minor. That's all that the statute requires. Doesn't require any state of mind. That's unusual. Again, most criminal statutes are going to tell you the state of mind that is required. Not only is it a crime to actually commit some of these prohibited acts, but it could also be a crime to attempt them. So like, I tried to kill my enemy, but I was unsuccessful. They can't charge me with murder because murder, the definition of that is taking the life of another. I didn't do that. But attempted murder is certainly against the law. There's a statute that says it shall be unlawful for a person to attempt to take the life of another without justification, with intent. So attempt can also be a crime. So what we've just kind of gone over is the fact that all criminal statutes are going to spell out the prohibited act. We call that the actus reus. It's the Latin term for that. And then if you've ever heard of the mens rea, that's the Latin term for state of mind. All the statutes are going to spell out an actus reus, a prohibited act, and a mens rea, the required state of mind. What about corporations? Can corporations, since they're not humans, can they be found guilty or liable for a crime? Sure. We can't put a corporation in jail, but we can sanction a corporation. We could shut them down. We could fine them large amounts of money. We could require them to take certain actions as restitution. Corporations are generally going to be liable for the acts of their employees or their agents who are acting within the scope of their authority. Or if the corporation should have known what they were doing was wrong. All right, I'm going to go through some different types of crimes, and keep in mind that these are not the only crimes. I'm just giving you a flavor of how different crimes are labeled and how they're defined and what might be required in each of them to have criminal liability. Violent crime, y'all already know, I mean, you're familiar with a lot of violent crime, hopefully not personally, but violent crime is the murders, the manslaughters, the assaults, the battery, sexual assaults, rape, things like that. Violent crimes, gun violence, gun crimes. We have property crimes. So like burglary, y'all have heard of burglary. We typically think of burglary as, or I've always associated burglary with theft. But actually burglary is breaking and entering by definition. So if I were to take a crowbar and break the window of the business school last night, I came in, I didn't steal any, I didn't take anything. But I still might be guilty of the crime of burglary for breaking and entering. You've heard of larceny. Larceny is the legal word for theft or stealing. There are different degrees of it. Petty larceny might be stealing something that has a value of less than $500. Grand larceny might be stealing something with a value of $50,000. The statutes are going to define what those levels are, so I'm just making those up. Larceny would be the wrongful taking and carrying away by any person the property of another. So if I take Alan's laptop, I may have committed the crime of larceny. I've also committed some torts. Remember we talked about those. Conversion maybe, trespass to personal property. The difference again being that the torts are what Alan could sue me for. The crimes are what the state of Georgia would sue me obtaining goods by false pretenses, like theft of power or theft of cable. I was thinking earlier, would use of somebody else's Netflix password be obtaining goods by false pretenses? I think it would.
If you have permission, I don't think it would.
But if you have permission, it's still the crime that you didn't commit a crime against the person whose account it is, but you might have committed a crime against Netflix. I think that's a good question. I'm glad you asked that. I think that might be obtaining goods by false pretenses. I was thinking the same thing. She said everybody's done that. I was just about to say we were all guilty of obtaining goods under false pretenses, and I didn't, because then I was like, well, I don't want to speak for y'all. I'm probably guilty of that. Receiving stolen goods. So it's a crime to receive stolen goods, even if you weren't the one that stole them. The key is whether or not you knew or should have known that they were illegally obtained. If I go to the jewelry store, a legit jewelry store, to buy a diamond ring, and it turns out it was stolen, then I've got a pretty good defense on that. There's no way that I should have known that Zales jewelry store in the mall was selling fake diamond, or not fake, stolen diamond rings. But if Michael is like, hey, psst, after class, I'm going to show you, I got some diamond rings for sale. Could be yours for $100. Where'd you get them? You don't need to worry about that. I just got them. Then I might, still arguable. I'm still going to go to court and be like, now how am I supposed to know where you got them? He's a good student, a reputable person. I trust him. How was I supposed to know that? It'd be up to the judge or the jury as to whether or not.
Get away with, like, since they did know, they get let off a little bit.
If they did know, wait, I'm sorry, ask it again.
Like the situation you just brought up with the whole Michael after class thing.
Yep.
You think a lot of times people that didn't know or say that they didn't know get away with it and don't get in trouble?
Problem. So the question is, do people just say they didn't know in order to get away with it? I mean, if I was the defendant, that's what my defense would be. I didn't know. And then who's it up to ultimately as to whether or not I should have known? The judge or the jury, right. So this is always going to play out in the courtroom in front of the judge and jury based on the evidence. My story might be, I've known Michael for 6 weeks. He's been a great student, a good person. I don't know anything bad about it. I have no reason to believe that. It just would depend. Depend on the evidence, the testimony, whatever they had against me. Remember, they got to prove it. The state's got to prove it beyond a reasonable doubt. So I got that going for me. That was receiving stolen goods. Arson, y'all know arson's pretty basic. It's the burning down of property of another. It doesn't have to be a building or a house, although we associate it a lot of times with the building or a house. It could be a car, it could be a mailbox, it could be somebody's, I don't know, a fence. Forgery, fraudulent making of a writing that changes the legal liability of another. Those are just some basic crimes against property that y'all are familiar with. They're public order crimes. That's another category. You're familiar with those. This is like disturbing the peace, public drunkenness, gambling, drug use, drug distribution, prostitution, things like that. White collar crime is probably the category that we associate most with business law. White collar crime occurs within a legitimate business setting. So the business itself is not criminal. We're going to talk in a minute about criminal business, a business that's set up for crime. That's racketeering and that's organized crime. This is legitimate business. The business itself is not criminal, but there may be criminal activity going on. Embezzlement is when somebody converts the property in a business setting that belongs to the business or the employer for their own use. Let's say I am a cashier at Walmart, and part of my duty is to handle payments at the cash register. Customers hand me cash. My job is to take the cash and put it in the register and safeguard it. I'm allowed to handle the cash. Nothing illegal about that. But when I start pocketing $5 out of every cash payment that I get, then I've converted the property that I was entrusted with that belongs to Walmart, made it my own. Even if you intend to return it, that's still embezzlement. Maybe I need to pay off my bookie tonight, but then I know I'm going to get paid tomorrow and I'm going to pay it back. And I do that. I pocket some cash from the cash register. I use it to pay off my bookie. My paycheck hits the next day. I withdraw some cash. I put it back in the cash register. I've still committed embezzlement when I took it and used it as my own. Okay, mail and wire fraud. This is a huge area of criminal activity. That is when somebody uses either the mail, the old school U.S. mail, or a mail carrier, like FedEx or UPS or something like that, or electronic means. And this is where the explosion has been. To defraud somebody of their property, steal from somebody else. Everybody that has a laptop open right now, I promise you could go to your email in your junk folder and find examples of wire fraud. People who are trying to scam you out of stuff. Back in the day, wire fraud would have been limited to like telephone, using the telephone in your fraud. I mean, there wasn't much wire. There wasn't much wire as there is now. Now this is a huge area. Anytime you use any electronic means, which is pretty much everything we do, right? Anytime that's involved in your crime, you've committed wire fraud. Bribery is a crime. You need to know that the offense of bribery, the crime of bribery, happens when you offer the bribe, not when it's accepted. If the bribe is rejected, the person who offered it can still be prosecuted and be guilty of bribery. So it doesn't depend on whether or not it was accepted or not. We think about bribery of public officials, and that's certainly a thing. I'm going to pay off the police chief to not prosecute me or my drug dealers. Bribery. I'm going to pay off a public official to choose my company to provide security or build a building or something like that, to get a contract awarded. But bribery could also be in the commercial sense as well. I go to Saeed and say, hey, I know you work for Aflac, and you guys are looking for a software provider, and I'm that. And if you can make sure that I get the contract, I'll pay you $1 million. I've just bribed Saeed. And he's not a public official, it's a private business, but it's still bribery nonetheless. I think this gets tricky in jurisdictions in other countries or maybe other cultures where bribery is expected, which is part of doing business. That gets a little tough because if you don't do it, you're not going to be a viable business. That to me, I think is tricky. But it is a fact of life in some places that's just how it operates. It is a crime to commit bankruptcy fraud, which is to declare bankruptcy, say that you can't pay your debts so that you're excused from paying them. If you really can, like hiding money somewhere when you really do have the assets to pay, or lying about your debts and assets. Theft of trade secrets. We talked about this last week in intellectual property. That's actually a crime. It's a good example of where one act might result in criminal liability for the person who did it, but also the company they work for. If I work for a Pfizer and I steal a drug formula from another drug company's research and development team through some sort of email scam or impersonating or hacking in to their system, I might have committed all kind of crimes. I mean, theft of trade secrets, wire fraud, who knows what else. I could be prosecuted for the theft of trade secrets as a crime, but my company could also be prosecuted too if they had some sort of knowledge about what I was doing, or they should have known what I was doing. I could be, let's say my punishment would be 5 years in jail or some fine. My company's punishment might be $5 million, or having to give up profits, or I'm not sure. But point being, one act by an employee could result in criminal liability for the employee, but also the employer. Okay, insider trading. This is like what Martha Stewart went to jail for. There are, from time to time, high-profile cases about this. I don't know the stats. I wouldn't think it happens a ton because I think it's really hard to prove. But insider trading is when a person, an individual, buys or sells stock in a company for profit based on some information that is not public. So you guys who are finance majors, our whole market is based on the idea that everybody's operating with the same information or the same access to information. Right? That's a foundational principle of finance. If my brother works for Pfizer and at Christmas he's like, hey, we've got this drug that's about to cure cancer. Nobody knows about it yet, but we've had a breakthrough and it's really promising, and I think this is it. And I go out and I buy Pfizer stock based on him telling me that. I've committed insider trading. The problem with that from a prosecution perspective is it's hard to prove. I mean, if they have I think Martha Stewart and them, there were like voice recordings. I don't know, there was some smoking gun. If my brother emails me and is like, hey, that cancer drug I told you about at Christmas, it's going public next week. We did get approval. It's about to get announced next week. If they can show that, and then they can show that the next day or that afternoon I went and bought Pfizer stock, that might be insider trading. If I'm at a basketball game and there's some guy on the phone 2 rows behind me having a private business conversation about, hey, that cancer drug that we've been talking about finally got approval. Yeah, it's not public yet. It's going to go public next week. I just overhear it. If I go and buy Pfizer stock based on that information, that's insider trading. Even though the guy wasn't talking to me, he didn't intend for me to use it, but I did. Problem with that is going to be proof, and that's pretty circumstantial. There was somebody there talking about, that'd be a hard case to make out in court. Just be suspicious timing, I guess, but suspicious timing is going to be maybe not enough to reach beyond a reasonable doubt. You know? Depends on if you're on who's on the jury or not, right? Organized crime is another category of crime. And we just talked about white collar crime where the business itself is legitimate. The business itself is not a criminal enterprise. In organized crime, the business itself is illegal. We exist in order to commit crime. That is our business. We are in the business of crime. Who said that? Say that again. Gangs. Yes. Organized crime. Dealing drugs. Organized crime. I mean, obviously the mafia is the most well-known example. The triads. I always think of the triads in what's that Jackie Chan movie?
There's triads and Yakuza as well. Triads would be Chinese, Yakuza would be Japanese.
Okay. Rush Hour.
Oh, yeah.
Yeah. Triads and Rush Hour. All the Rush Hours, I think. But yeah, so that's organized crime. Money laundering is a form of organized crime. That's when we have an illegal business disguised as a legal business. My cocaine distribution business, T-Blow, it's pretty good. Just thought of it. T-Blow, Inc. I make $50,000 cash a week from T-Blow. I can't go to Synovus and deposit $50 cash every week without setting off some alarms. I can't file a tax return in April for T-Blow Inc. and tell the government that I've made $4 million last year selling cocaine. I could keep it all, I guess, in my basement. But money laundering exists to take money that's earned through illegal means and clean it, launder it, make it legal. So because I can't open up a bank account for T-Blow, I might open up a bank account for T-Bow's Pizza. All right, I might open up some pizza parlor in a strip mall in Midtown Columbus, and I will take my cocaine profits and I'll deposit them in the T-Bow Pizza account at the end of every day as sales from my restaurant. That way I've cleaned it, I've laundered it, I've made it legal when it was not earned legally. That's money laundering. Racketeering is, y'all have heard of racketeering? That is a crime that was kind of invented in the 70s, and it was aimed at the mafia. They were having trouble prosecuting people who were involved in the mafia and organized crime because the enterprise was kind of sprawling and far-reaching, and not everybody knew what everybody else was doing. You know, you had like your lower-level street operatives. They were just told, you go to this business every month and collect $500, and then you bring it back to us or whatever. You have no idea what it's for, what it was about. You don't know what the higher-ups are using all that money for. They might be buying guns. They might be running drugs. And they were having trouble bringing down the heads or the bigger people in the organized crime because they couldn't prove it. So they passed these laws, racketeering laws, which said basically if you're involved in a part of a larger criminal enterprise, you could be guilty for everything else that's going on. That's racketeering. Conspiracy is a crime as well. Conspiracy is just the planning of the crime, not the execution of it. And conspiracy is another legal theory that's used a lot in organized crime, because under the definition of conspiracy, if you were part of any, if you did something in furtherance of a larger crime, you could be charged for the whole thing. So like if I tell Jevin that I need him to pick me up at the CB&T branch down there at the mall, and to wear a ski mask and be prepared to drive really fast. He's got to be there right at a certain time when I give him a signal. And I plan out with Samer, he's going to get me the gun that I'm going to use to rob the bank. And then I plan out with Tristan that we're going to drop the money off somewhere, and then he's going to go pick that up, and then he's going to go. And anyway, Tristan didn't have any part to do in the actual robbery. Jevin didn't. He's just a getaway driver. Samer didn't. He just got me the gun. But we could all be charged with conspiracy to commit bank robbery because we were all part of the plan to do it. All right, defenses to criminal liability. So shift your thinking for a second to the courtroom. The state or the federal government has charged somebody with a crime. The defendant is the person who is alleged to have committed it. And the government has to prove beyond a reasonable doubt that they did it. The defendant is going to use all of the defenses that he or she has available to him, right? Some of them would negate criminal liability. Some of them operate to say, yes, you did it, but you had a reason for it that we accept as a reason for it that will prevent you or will negate your criminal liability. One defense is justification, self-defense. It was necessary for me to commit the crime to protect myself or others from being harmed. Usually, and this can vary by state depending on how they define it, but usually you can use just the amount of force that's necessary to protect yourself, your dwelling, or others. Not anything that's in excess of that. So like if somebody were to walk through that door right there with an automatic weapon and a ski mask on, and I've got my automatic weapon right here and I open fire on that person, that's pretty much equal force, right? I mean, he's got an automatic weapon, I use an automatic weapon. If somebody walks through that door who's a disgruntled student from last semester with a stick, who's like, Tebow, you failed me, you're gonna get it once and for all, and I'll pull out my automatic rifle, I take care of him before he even hits the first step, and I get charged with whatever crime, gun crime, whatever it is, murder, assault, whatever it is they decide to charge me with. And we go to trial and I use the justification defense. The jury's going to have to decide if that was reasonably necessary to defend myself. Maybe not, right? But it's going to depend on the evidence and the specific facts that are laid out before that judge and that jury. Now, think about this practically, okay? Somebody comes through that door with a gun or a weapon. We don't say, hold on just a sec, time out. I need to decide what level of force is reasonable here. What do y'all think? Should I shoot him? Should we run? Should we call the police? Do you think you can take him? I think I can take him. You know, that's not how it works. These are split-second decisions that we're really being judged after the fact on whether or not what we did was reasonable. Think about the, y'all know remember the Ahmaud Arbery case down in Brunswick, Georgia? That's pretty recent, some within the last 2 or 3 years. And those guys, Arbery was jogging through the neighborhood. Y'all remember this, the basic facts. And there had been some break-ins in that neighborhood. Some residents saw him, thought he was a criminal, chased him, thought he had a weapon. They ended up shooting him. And their defense was justification. But the jury did not accept that. The jury found them guilty of whatever. I don't know if it was murder. I can't remember what it was. But anyway, the jury found them guilty of that. Justification. Necessity. Necessity could be a defense if the act was necessary to prevent other harm. Like I'm walking by I'm walking downtown past a storefront at night, store's closed, I see there's a fire in there. I take a crowbar and break the door down to go in there and put the fire out. I get charged with burglary for breaking and entering or destruction of property or whatever the crime it is. My defense would be necessity. It was necessary for me to do that. I see somebody mug Alan after class, holding him up at gunpoint. I go up behind him and knock the guy out with the crowbar. I could be charged with the crime of assault, battery, or both. And my defense might be it was necessary for me to knock that guy out because he was going to hurt Alan. Necessity. Insanity. Why is insanity a good defense? Or why could it be a good defense? You're not in your right mind. So what does it negate? Right.
The frame of mind.
Yeah, it negates the frame of mind. Remember, every criminal statute is going to tell you what the prohibited conduct is and what the state of mind is. If I can prove that I was out of my mind, that I had no idea, I couldn't appreciate what I was doing, I wasn't in control of my actions, then that might negate the required state of mind such that I'm not guilty of the crime. Insanity is it's not easy to prove. It's very difficult to go in a courtroom and show what was going on inside somebody's head with any type of certainty.
I had to watch a movie in my sociology class about this woman who had been getting abused, and she ended up killing her husband. Like, I think she had kids with him too, and she ended up setting the house on fire. But the best way that she got proven innocent because of insanity. But I think the only reason why is that she told her whole story out, everything that happened to the jury.
Yeah, you do see some cases like that where people have killed somebody as a result of long-term abuse, PTSD. There's a battered spouse syndrome. There's some things like that that can operate as defenses. That's a great example, Ethan. Mistake. All right. Mistake is tricky as a defense. Mistake of law is never a defense, meaning I didn't know it was illegal. That's never a defense. It might happen, right? Do you guys, Samara, Camilo, do you guys worry sometimes that you might be doing something that you don't know is illegal under American law? I would worry about that if I went to your countries. I just don't know everything. But mistake of law is not a defense. Mistake of fact, on the other hand, could be a defense. Not always, but could be a defense. Mistake of fact could also operate to negate the state of mind like insanity did. let's say that Ryan and I have the exact same laptop computer. There are no distinguishing markings on the outside that would tell his from mine. He leaves one day and leaves it sitting right there in front of us. I take it thinking it's mine. I get charged with whatever theft crime the government decides to charge me with. They've got to prove that I took the property of another, however this is defined, knowing that it was somebody else's property. Well, they can't prove that if I can show that it was a mistake of fact. I didn't think it was his. Now, if his laptop says property of Ryan Janeway on it, I'm going to have a lot of problems with my mistake of fact defense, right? But maybe not if they're identical and he left it and so on and so forth. If I go and get it out of his car, probably not mistake of fact. So mistake of fact is sometimes a defense. Mistake of law is never a defense. If you operate a business in other jurisdictions, maybe even other countries or other states, and you don't know, you're doing something that might be legal in Georgia, but it's illegal in Alaska, mistake of law is not a defense to that. Entrapment. Entrapment occurs when a government official not forces, but coerces or tricks the defendant into doing a criminal activity. You see it a lot with you don't see it a lot, but like if we're talking about TV crimes, prostitution, things like that, where the prostitute is an undercover cop and they keep on bugging the person until they say the magic words that get them arrested or they ask for the thing that's prohibited. The key to entrapment, though, is whether or not the person was already predisposed to do what they were going to do. If I've gone downtown and my whole purpose of going down, I'm say downtown, I've gone somewhere where I know all the prostitutes are, okay? My whole purpose of going there was to hire a prostitute. But it turns out that the one that I hired was a government official. That's not entrapment. I was there to do that. That's what I went for. But if I'm somewhere at the mall, I'm not looking to hire a prostitute. I'm not in a place where one would go to hire prostitutes. And somebody comes up to me and they're an undercover officer and I won't say trick, but the conversation is such that it's not me of my own free will. That could be entrapment. Duress is when somebody makes a threat of harm against another person that causes them to do criminal activity that they otherwise would not have done. If I walk into my neighbor's house, she's an old lady, she's 95, and I hold a gun to her head and say, I want you to take your husband's checkbook and write me a check for $1 million and sign his name to it. And she's committed forgery by definition. But her defense might be duress. I was forced to do it. If Tebow hadn't had a gun to my head, there's no way I would have done that. I didn't do this of my own free will. One of the keys to duress is it has to be sort of immediate danger. And if I go to this old lady's house and tell her that if she doesn't write me a check on her husband's checking account and get it to me by May 1st or else, that might not be duress. It might be duress of the last day of April if she still hadn't done it. But if it's February and she hasn't done it, she could go to the police. There are other things she could do besides commit the crime. So that might not be a good defense. Statute of limitations. So there are some laws that say that after a certain amount of years pass, the government cannot charge somebody with a crime, that's called a statute of limitation. There are statute of limitations for most crimes, except for the most serious, the most violent ones. Famously, murder is not, there's no statute of limitations on murder. I could have murdered somebody when I was 10, and I'm 95, and they charged me with it. They could do that. Most other crimes, like if I stole something from one of y'all today, 50 years later, the government charges me with theft of personal property or something, statute of limitations might have run on that. It's not really a blanket. It kind of depends on the crime, specific to the crime. So that's why I'm being vague about how long it is. It just really depends on what the law says. Immunity is also a defense. We don't really get to this trial stage where a defendant says, by the way, I'm immune. If a person is offered immunity for their testimony, in other words, you testify, you give me your evidence against this crime that this guy committed, then we won't prosecute you. That's immunity. But it's a defense to criminal activity. Yes, I did. All these defenses are, I might have done the act, but I had a good reason for it. And it's a reason that society has accepted as justification for my actions. So on Thursday, I'm going to talk a little bit about some constitutional safeguards that we have in criminal law, like the Fourth Amendment, which requires law enforcement to have a warrant before they can search any of your personal property or your business. The Fifth Amendment, which protects against the right for self-incrimination, things like that. The case that I've assigned you to read, Carpenter versus U.S. for Thursday, we're going to discuss that. That is the has to do with illegal search and seizure. And like I did this past week with the quiz, I'm probably going to lean pretty heavily on that Carpenter case because I think that's an area where it's harder for ChatGPT to tell y'all what the answer to the question is. So not many people read last week. Please read that case before Thursday so we can have meaningful discussion about it. And then you do have, for this week, just one quiz. It's due Monday. And then you have one discussion question. And the discussion question is about Florida law and how much force Florida allows a homeowner to use to protect their home. And so the question is what you think about it. So this is a great example of how you ought to be using AI. The question tells you what Florida's law is and then asks you what you think about the pros and cons of Florida's law, about Florida's approach. So a smart use of AI would be, hey, ChatGPT, tell me some basic pros and cons of using force for defense of property. Familiarize yourself with what the arguments are. Then I want you to tell me what you think about the Florida law. So if you're using ChatGPT or whatever it is you're using to educate yourself about the subject matter or to give you ideas or reasons, that's very smart of you. That's a form of research. I mean, that's how this is supposed to work. You can make a much more informed answer if you educate yourself beforehand, and that's one of the ways to do it. If you use ChatGPT to give you the answer, that's not what I'm looking for. So I think it's a great example of how you can incorporate that and how you ought to be using some of these tools. When I read your responses to discussion questions, I'm always asking, what do you think? What is your analysis? Now you gotta support your analysis with good reasons. And that might be appropriate times to consult artificial intelligence. But I don't want it to tell you what you think. So when I read those questions, that's what I'm looking for. Can you tell me your opinion and your analysis based on whatever source material you want to use? All right, so Thursday, read the Carpenter versus U.S. case. I'll have a lot of discussion to do on Thursday. I'll have a little bit of lecture. You have a quiz due Monday, one discussion question this week. And we're just doing 1 week on criminal law. Anybody have any questions or comments on this? All right, let me, if you came in late, looking at Ms. Castillo, Mr. Alexich, make sure that I got you. Let me see. We might have had everybody here today. All right, Castillo, I got you. Xavier. Miss Lagone, I got you. Grace, I got you. And Alan, I got you. I don't know how I had you going. All right, y'all are good.
You could ask questions on quizzes
Yes.
in context of what you said.
Yeah. I mean, I'm more writing them in terms of,
What did I say about this?
yeah.
And then if it's different than what you said.
If you run across a question like that, shoot. Because I'm not intentionally trying to say, I could be wrong, I guess is what I'm saying.
Right, but worded, for the wording